Call this meeting of the Conference Committee on House File 2115 to order. Members, take your seats. Look at this. It's a script. Unbelievable. Senate members, we have never had scripts in our entire life, but the House is beautiful. This is just awesome. I've never seen anything. I want to thank Nick and Megan. Nick, is this how you guys do your business over there, Joe and Noor?
Mr. Chair, this isn't in the script.
A quorum is present. This is fun. I'm a drummer. You're giving me a script.
And you're supposed to gavel in.
I did gavel in.
With the quorum present.
We're good. So, members, the motions that we're going to be doing below reflect the latest technical assistance and collaborative work at the Department Advocates Providers House. I just said the House, the other body in the Senate. If there are questions on the actions that we're taking, let's just handle them as we go along. So members, please make sure you get my attention or my staff's attention, and we'll do that. So if you want to jump in, please jump in. We have individuals here from the Department of Human Services, Direct Care and Treatment, and there's some other groups here to answer those members. And so if there are any questions on this process, we can proceed. Seeing none, let's go to Article 2. Senator Rasmussen.
Thank you, Mr. Chair. I would move the A12 amendment and happy to briefly explain it.
Members, the A12 is in front of everybody as it's being passed out. Senator Rasmussen, the mic is yours. Thank
you, Mr. Chair. This is regarding to a historical preservation project and assisted living facility. I'm grateful to the Minnesota Department of Health for providing technical assistance since this passed off the floor, and so this is their recommended technical assistance language. So we're deleting what is currently in the Senate bill and inserting this language here that would allow a Type 3B building in Ottertail County that is a historic building on the historic registry to apply for assisted living licensure. This building was previously an assisted living licensed facility, and so this is just making sure that they are able to apply and have the Minnesota Department of Health review their application.
All those in favor of the A12 amendment signify by saying aye. Aye. Opposed, same sign. It is adopted. Let's go to Representative Noor.
Thank you, Mr. Chair. I move the adoption of A16 to the House language Article 2, Section 19.
Members, the A16 is either in front of you or it's being passed out. As it's being passed out, Representative Noor, will you please discuss the A16?
Thank you, Mr. Chair. I think this is making some changes by removing comprehensive on the LPN providing services in an assisted living capacity, also making sure that all the stakeholders have agreed to this language. So, Mr. Chair, I'll ask for yes vote.
Questions, Senator Representative Shoemaker.
Thank you, Mr. Chair. And I'm just wondering, I know that the stakeholders were working on this. I know comprehensive was a word that was considered important to a lot of the groups. Who was requesting that the comprehensive piece come out?
Representative Noor.
Thank you, Mr. Chair. I think this is something that the stakeholders were working on to make sure that M&A was involved, the department was involved, all the other stakeholders were involved in reaching the consensus.
Representative Schumacher, follow up.
Thank you, Mr. Chair. I think I heard what I was looking for.
Senator Rasmussen.
Thank you, Mr. Chair. And I have some concerns on this because I believe that there was compromise language in both bills on this issue that included comprehensive. And I remember, Mr. Chair, in the Senate hearing, we received feedback from the Minnesota Department of Health, and I believe all those changes were adopted. And so I wanted to make sure that for the long-term care providers that this addresses their concerns that they had, because I thought we'd adopted all of the feedback. So I just want to make sure I understand what the amendment does. So
thank you, Senator Rasmussen. Representative Noor, Lisa Timian is at the desk. Ms. Timian, please, for the record, say who you are, and nice to see you.
Yeah, nice to be back, Mr. Chair, members of the Conference Committee. For the record, my name is Lisa Timian. I'm Director of Government Relations at the Minnesota Department of Health. Senator Rasmussen, to your question, yes, this had been some compromise language, but then as we were getting closer to the conference committee, as tends to happen, there was some additional refinement and discussions among stakeholders, as well as the Department of Health and the Board of Nursing, to just get to a better language on this.
Senator Rasmussen.
Thank you, Mr. Chair, and appreciate Ms. Timmy coming up there. I'm okay with the amendment, so thank you.
So seeing no other discussion on that, all those in favor of the A16 amendment indicate by saying aye. Aye, opposed, same sign. A16 is adopted. We're going to the Article A19. A19. You know what? How did you get the A19? That's like Steely Dan. Is every time somebody gets the A19, this song goes off in my head. Representative Schumacher.
Thank you, Mr. Chair. I'm sorry for the songs that are in your head right now. The A19 amendment is really just, I won't be having this come to a vote, but just to make the larger point on this, we have language that we were working on in the House that hopefully we'll have a further discussion on today about guardianships and so. And as we were going through the process, we got the language in the bill that we could agree to at the time in hopes that there would be further discussion later as we had more stakeholders involved in the conversation. Unfortunately, the language that we have here is from stakeholders as well. We weren't able to get the other stakeholders on board to even continue the conversation on it, which is an unfortunate part of this process overall. There are issues with that agreed upon language in the guardianship piece there, one being just the implementation date, and then other things like we see in the subdivision 1, where we're referring to the way things used to be done before we had assisted living licensing, and those pieces there. I understand we don't have the support to adopt this amendment today as it is, and really don't like that, but that's the way it is this time. And just wanted to use this moment and this amendment as a piece to highlight that there isn't total agreement with the language that we have coming up, that there are better ways to do it that would do more to protect the seniors that we're trying to protect with that. And so I can open it for discussion or just withdraw the amendment.
Members, discussion or withdraw? Representative, the A19, one of my favorite songs of all time, is withdrawn from the committee. Senator May Quaid.
Thank you, Mr. Chair. I think before I do my amendment, I would like us to have a little bit of a discussion and maybe a little bit of testimony or Q&A as it relates to the transition pay from private to public pay. So if folks go to R17 in the Article 2.
So, Senator, is your amendment being passed out, or do people?
It's going to be an oral amendment, Mr. Chair.
Okay.
And it will depend on where we land in this discussion between the House and Senate.
Awesome. So the table is yours.
Thank you, Mr. Chair. So the Senate language here on 36.22 Senate side, impermissible ground for termination. A facility must not terminate an assisted living contract on the ground that the resident changes from using private to public funds. And then on the House side, it's a little, there's a few more requirements. So there's that same language about not terminating a contract. And then there's requirements on informing residents about their policy regarding private to public fund transfers. And so I would like us to just chat a little bit about this because it'd be great to hear what the House, how they arrived at this language. I think we have some folks in the audience who might have opinions as well, so let's have a little discussion.
Senator?
Thank you, Mr. Chair. Okay.
Representative?
Guide us exactly where we are in the statute.
Thank you,
Sure.
Representative Gander.
Thank you, Mr. Chair. If you go to R17 on Article 2, it's Section 17 House side, Section 26 Senate side.
Everybody finding it?
Mr. Chair?
Representative Schumacher.
Yeah, thank you, Mr. Chair and Senator May Quaid. With that piece, there is a feeling that, or that there's not a feeling, it's fact that not every situation is the same. When we're dealing with assisted living, there are the discussions that Representative Moeller and I had on this. She was taking that there are bad actors in the assisted living world. I was looking at it from the perspective for that healthy balance of there are also bad actors on the resident side of things too. And so if we have a system in which we've set up this process where the resident has no accountability in that process at all in trying to, they're assured a spot even if they do nothing to help assure that spot, that gives them undue leverage in a system overall. When an assisted living is trying to make their books work in their business, there's a number of spots that they have budgeted for elderly waiver versus private pay, and the more notice that they have, the better ability they are to accommodate those pieces. The language that we have here makes it so that there is a mandate or an expectation that beyond just we'll try to budget for it, that there will be a spot for you. And we've reached this language piece saying that the resident also has to have a stake in that. There has to be a process that they participate in, that they have to give notice, that they have to be watching their funds well enough to know so that they can do the process of getting involved overall in that. I think the final point too with that is that we know through testimony all year that the county has trouble getting the applications, especially for these waivered services, done in a timely manner. And that's the other piece that the assisted living struggle with, is that sure, that person may be eligible for elderly waiver and they would have the room for them, but there's a time lapse between when the application is done and when that gets approved because of the systems that the counties are dealing with. And so with this, because of that extra notification time, that allows them to have that piece, and then also offers extra assistance to make sure that those applications can get done. And so I hope that helps answer what you're looking for with that.
Thank you, Mr. Chair, and thank you, Chair Schumacher. I appreciate the delving into what happened. I think we can say House. If we're in a conference committee, we have House members in the room. I think we'd say House. What happened in the House? So I appreciate that. We had in our Senate committee some really heartbreaking testimony, and we actually had some personal stories on the committee as well. Senator Gruenhagen shared that this is something that happened to his mother, that she transitioned from private pay to public pay and was kicked out of her nursing home. And so I think that doing something here is really important, and I think that we could take the House language here.
Okay.
If I was going to offer my amendment, it would be to take the House language, except lines 26.30, 26.31, and then on 26.32, delete up through agencies. And the reason why is I want to make sure that, just to repeat something Senator Rasmussen said, that we don't need to have lawyers on retainer to live our daily lives. If it's going to be a requirement that someone notifies of their intent to transition, we're asking people people who are living in long-term care to know and have the foresight to not only start the application process and know where their funds are, but also I have to notify this residence that I live in. And so going with the other notification pieces I think is important, but I would like to strike that language and adopt the House side.
So Senator, it sounds like we're good with the House language. You just want a little clarification on it, and give me those numbers once again that you just rattled off.
So strike 26.30, strike 26.31, and on 26.32, strike up through the word agencies and the period.
Strike got it. And so then you're saying the language would then start with the word the facility, correct?
Correct, Mr. Chair.
Representative Chair Schumacher?
Thank you, Mr. Chair, and thank you, Senator McQuaid. I would oppose that amendment for the reasons that we stated before, that part of our agreement to get to this point was that the resident has to have more responsibility in the process there.
Senator?
Thank you, Mr. Chair. I don't know what the testimony was like in the House, but one of the concerns that we heard was notifying a facility of their intent to move from private to public funds would result in the removal of that resident before they could transition to public funds for other reasons, retaliatory reasons. And I guess I'm just trying to imagine a world which, families and residents are navigating complex systems, they're working on applying for public programs or navigating a county system and putting it into I don't know how one would know that this is a requirement, that this is in law. And I worry about creating a legal system that is, like, the presumption of knowing it is low. You have families that are navigating lots of different situations, and then on top of it, having to know all the information that they tell a facility, we intend to do this thing. I don't know, it doesn't sit quite right.
Chair.
Thank you, Mr. Chair, and I guess the pushback I would have to what Senator McQuaid just mentioned is that there is an assumption in her statements that the family's involved, and in a lot of the cases where issues arise, it's because the family's not involved with that. Not everyone has the benefit of having family, or sometimes those are estranged, or sometimes the family has different motivations than what is best for the senior in the care with that. And then to the point of how would the resident even know that this was a requirement? That's part of already in another part of statute that those pieces get reviewed every time the lease is reviewed, and however that's set up. And then every time that the center has a conversation about this, the assisted living can't ask about what are your finances right now, but talking about their rights and what's in as part of their lease with every conversation. And this would have to be a part of that piece too, as already prescribed by law.
So, Senator, I'm wondering on that one, Mr. Chair, is there a process right now? Because I know a lot of people that don't even know the system of public pay exists. I can anecdotally tell you, is there a system right now that triggers that, clicks it off that somebody's doing it? I mean, that sentence right there, what's the piece on that sentence that seems to be discerning for that? And does a system already take place in there? I'm just kind of asking that as a follow-up.
Mr. Chair, I don't know that there's a system that triggers that, and I think that's part of the issue is that if an assisted living is trying to make sure that they can operate and stay open, and the elderly waiver piece is lower with that they need to have time to be able to manage what they're dealing with as far as their customer base and their payer base with that. And because there's no mechanism now to identify that, because it's not the assisted living that can go in and ask for the financial records or where they're spending their money and those sorts of things, they don't have that ability. And without the resident being involved in that process, but then still having the protection of this language without having the responsibility on that end, it could easily, in my view, and part of the reason why I still have problems with the language as it is today, is that there's still, for lack of a better word, an opportunity to game that system for the residents.
Thank you. Thank you. I'm asking, Chair, I got Preeti Rudini, who is our ombudsman of Office of Long-Term Care. I asked her to come up because she looked like she had something to say on that. Could you help us understand? And please, for the record, state your name.
Thank you, Chair Hoffman. Preeti Rudina, Office of Ombudsman for Long-Term Care, here today on behalf of the Consumer Advocates Coalition. And I think where we agree, Chair Schumacher, is that the min-choices and elderly waiver application process is complicated. It is hard for people to navigate. That is true. And I think where we don't agree is where the responsibility for that navigation should lie. Vulnerable adults should not be responsible for figuring out how to get on elderly waiver. That should be done with the assistance of the provider, who ultimately benefits through payment and through county support to be there to help residents. You know, and I also do think that in the case of a resident who is, or a family member who is delaying the application process, in that instance you're describing, you know, that I think there is already protection for providers in statute in terms of termination of contract for non-payment. There is language in 144G that acknowledges that a pause in public pay that is not the result of the resident delaying their application is not grounds for termination, but if the resident is delaying, that can be grounds for termination. So I do think that protection already exists in 144G for providers, and the intention of this language is really to protect vulnerable adults who get that promise up front when they move in, that they want to, that they can stay in their home, they can switch to elderly waiver when they need to, and then all of a sudden they get to that point where it's necessary. The resident is communicating with the facility, the family's communicating with the facility, and suddenly there aren't any elderly waiver beds available. And that's the situation we're trying to.
So I'm wondering, the term vulnerable adult, how do you define vulnerable adults, Ms. Perice?
In the Vulnerable Adults Act, it is defined as an individual who lives in a facility, among other things. So
that in and of itself, because it's not like, we know in Minnesota 1 in 5 people live with a special health care need, 1 in 10 is chronic, 25% of them. We know these statistics. That's just anybody in the Vulnerable Adults Act that's in there is how you're referring that. Okay, that helps me understand. Senator Maquaid.
Thank you, Mr. Chair, and I appreciate that context. And maybe what might be really helpful, Chair Schumacher, is that I think the word that's getting me here is intention, of somebody's intent to apply. And I don't want to go too far into the legal weeds, but like, at what point does it become somebody's intention? When they think about it, when they've like had a conversation, it's just the like vagueness of intention. If there is a better, like that they are applying or that they have applied or something that's like more concrete than kind of getting into like thought crimes, like, is there a better word than intention? I feel that if we had a better word, then I think we could accept that whole piece. I'm not against folks having to notify of a thing that's happening. Intent is what makes me nervous.
Chair Schumacher, then we'll go to Senator Rasmussen.
Yeah.
Thank you, Mr. Chair. I would say then with that, the A19 amendment would have been the better piece with this, because there is a clear delineation of intent and timeline with that piece.
Senator Rasmussen. Senator Maquaid, what's the dream of the body here? What do we want to do?
Mr. Chair, I would like to have something. I think because it's in both bills, I think we should come out of this conference committee with something that reflects this intent.
Do you and Joe want to go look at do we want to revisit the A19? Not that I like Steely Dan, the band, but you know, the fact is, if what Chair Schumacher is saying is, then if that's the case, then we should revisit. He didn't say revisit, he said that we should take the A19, so.
Mr. Chair, I don't think we should take the A19. I think the A19, I like it less. And so for right now, let's move to adopt the House language on here.
So members, so we're scratching off the oral thing. Do we even need to move the House language on that? Yes, we do.
No. No, we don't need to do it yet.
No, that's what I thought. We're good. Because that was not a, hey, guess what? It's not in the script, so it's probably written someplace else. I'm glad you guys are still laughing. You know what? This has been a hard year for us. These both committees, and I'll tell you what, you know, having some grace up here is something I think we all have, and I appreciate the work that everybody has done on this, because we're focused on those people that need the services the most, and so I appreciate that. Representative Gander.
Thank you, Mr. Chair. I offer the A13 amendment. This amendment updates the effective date to August 1st of 2025.
Members, the amendment is either being passed out or you have it in front of you. Any questions for the good Representative Gander?
Mr. Chair, I'm sorry, which effective date?
The A13, no, this is not the effective date. This is the completed in isolation ending. That's a different amendment. Do you want to, go ahead, we'll scratch that opening comment. Representative Gander, do you want to move the A13? Would you move the A13, but I think the piece on here is something different than what.
Let's look closely here.
Yeah, we're good.
Mr. Chair.
Representative Gander.
So I have a clarifying update from MDH, and you can see the wording there. It changes after the completed, it inserts prior to isolation ending.
All right, members, you see the wording there? Any clarification needed on what we're doing? Yep, we'll wait, Senator. Do you know any more? Do you have any more information on that, Representative Gander, that you want to share with the group? What are we prior to or completing? I guess we can.
Page 22 lines.
Let's just do that.
Mr. Chair,
Senator.
may I ask nonpartisan staff to explain what this is? I am not familiar with this piece.
That's fine. Who would like that? Mr. Monahan.
Mr. Chair, members, the Senate A13 is a technical change requested by the Department of Health. It is related to significant change in status, comprehensive assessments following isolation. They wanted to clarify which assessment was relevant for determining whether there was a change of status following isolation.
You good? Representative Gander, you're good? All those in favor of the A13 amendment say aye. Aye. Opposed, same sign. It's there. Representative Newer, Chair Newer.
Mr. Chair, I'll move the House 820 to standard language Article 2, Section 14. This is the provision that the stakeholders have agreed to. It's
And members, it's being passed out right now. Representative Chair Newer, do you want to tell us about, keep going?
this is in regards to the hospice. So we're making minor technical changes. We're deleting pain and also delete immediately and insert readily on page 32, line 24. And also page 32, line 27, after the comments in collaboration with hospice providers, if possible.
So, Mr. Chair, Senator, Representative Newer, this was technical assistance that was given to you by one of the departments?
Mr. Chair, as you know, we always bring people together. And this was a conversation from the hospice and also some of the advocates who worked on this language. So this is a more compromised language that they've agreed to.
The first thing that sticks out for me, members, is the word "if possible," right? Is there any statutory reference to the word "if possible"? I mean, are you guys comfortable with the term "if possible"? It's kind of.
I think Mr. Chair, I think we have Christina in the room and also Michelle, so that they can. The hospice, I think. No, I don't see
anybody. Are you comfortable with this? You guys good? I just don't like "if possible." What you guys? Are you Aaron?
Mr. Chair, I think
go
I've
ahead.
seen also Susie.
Susie Scheller? Is Susie Scheller, you good with this wording? Where is she?
I have I had the discussion with them. So
Matt Freeman okay with this? I mean, is it?
I think he's smiling. So
You're good, Senator Mayquade.
Thank you, Mr. Chair. This is
You're good.
aligned to what Senator
Okay.
Rasmussen and I agreed on. I think this is
Oh,
fine.
you guys. This is what you guys. I'm
Yeah.
sorry. I should have just gone to you two right away. I'm just thinking.
Although we agree, if possible, is awkward, clunky, but it's fine.
Good. I'm glad my two experts in this. We're good. All those in favor of the A20 amendment in case saying aye. Aye. Opposed, same sign. There it is. We're going to do Chair Representative Schumacher. You got the A15. Folks want to start handing that thing out? Thank you.
Thank you, Mr. Chair. The A15 amendment to this is clarifying on the designated support person language. There was concern that the designated support person could end up with essentially becoming a resident or having squatters' rights in a skilled nursing facility. This language is attempting to make sure that that isn't a case or concern for that, but still providing support for the designated support person in those facilities.
That makes sense to me. Senators Rasmussen, Mayquaid.
Thank you, Mr. Chair. I think when we were looking, I think the language did need to be tightened up a little bit. I will just say, very much support the intent. I think it's a great concept. We were going to recommend that the chief author work on the bill and come back next year, in part because I think changing any statute about pregnancy to like fit with long-term care, it's a little bit of an awkward fit. But and the squatters' rights was, or the squatter piece was a concern when I read the language. I don't think this is objectionable.
Okay.
I just think it's, I don't know if it's totally ready, but I don't know if it's going to harm anybody in a year.
You're good? You good? All those in favor of the House A15 indicate saying aye. Aye. Opposed, same sign. Here we go. We're going to, that's it. Members, we're now going to look at motions that, to adopt language from Article 2. We have Senator Mayquaid. Do you want to make a motion? You want to look at the Senate language, Article 2, Section 7, 15, 16, 18, 28, and 34? Senator Mayquaid, you want to make that motion?
Mr. Chair, I do, after I look at it.
It's yours.
Oh, then, yes, Mr. Chair, that's my motion.
All those in favor of the motion to adopt Senate language, can we just do these all as one, or do we have to do these individually? Rasmussen, what are you thinking? You want to talk about it? Somebody there wants to
Thank you,
talk
Mr.
about
Chair. I think this one is maybe, has some controversy to it, so I just,
Okay.
maybe we have Sarah Mayquaid repeat what we're adopting, and then we can hear if members have objections to it.
Do you want to go there first, or do you want to take a question right away from, there's some clarification?
Sure. The sections are around restraints. Yeah.
Okay. Joe? Go ahead, Chair Schumacher.
Yeah, thank you, Mr. Chair. The House intentionally did not hear these pieces. We have a 67 body that we need to try to get things through. The restraint pieces, as we look at it, are over-prescriptive with what they have. And I think there is an opportunity to get to some kind of compromise piece at some point in this. This isn't that piece, and today's not the day. So I would encourage a no vote.
Senator Mayquaid.
Thank you, Mr. Chair. I will just say, so, and I mentioned this yesterday and I'll mention it again, these facilities are outliers when it comes to how we have regulated, particularly when we're talking about vulnerable populations. We have restraints language in the special ed statute, the general education statute, prisons, jails, group homes, pretty much any setting in which government is involved in the care of or the providing services of drug care and treatment. And so, these facilities are outliers, and I think we've heard pretty loud and clear that we're both missing this regulatory language, and the potential for harm is immense. And I don't know if this is particularly controversial. Like, I think leaving it out would be more controversial than adopting it, personally, because it just is, it is an oversight. It's a gap that we have currently in statute.
We're good. Any other further questions? No? You want to get MDH up here, or do you want to vote? Because
Let's take MDH.
all right. Come on up. God, I've seen you more today than I did all year. Welcome. This is cool. For the record, will you guys just say who you are?
Mr. Chair, members of the conference committee, my name is Lisa Timian, and I'm Director of Government Relations at MDH. In fairness, Senator, I was out for part of the session with a bum ankle, so I hadn't been here as much. But Thank you for your comments, Senator McQuaid. This restraints policy language actually was a result of discussions in that assisted living work group that really got reinvigorated with some funding from the 2023 bill from Senator Knorr and Representative Knorr and Senator Hoffman. I'm so sorry for that horrible slight, Chair Knorr. So the current statute is silent on the use of restraints in assisted living settings. This leads to confusion about the appropriate use of restraints. So there's added language regarding the use of restraints would provide important clarity to both the providers and the residents at these facilities. As part of our stakeholder discussions, we did discuss this. This has actually been something that we've been discussing since 2019 when the law was first being drafted. We had a lot of discussion among the provider organizations, consumer advocates, as well as Department of Human Services and Ombudsman for Long-Term Care. We really tried to be consistent with the statutory language from 245D statutes, as well as the nursing home rules. And we just really tried to keep that as consistent as possible. The way it would work under this language is that facilities would report their use of restraints to us, which would allow more awareness of restraint use and reasons for the restraints. This also fulfills DHS's need for data for their waivered payments. We do not anticipate a high use of restraints, and we do know that nursing homes have been seeing a decrease in the use of restraints over the years, but again, we just really see this because the statute is currently silent in this space. We do see this as aligning with other facility regulations.
Ms. Rodina.
Thank you, Chair Hoffman, Paricha Redina, Office of Ombudsman for Long-Term Care, Consumer Advocates Coalition. I think Ms. Timian laid out the reasoning. I just want to give you two quick stories that illustrate the why for why this is needed. In a memory care unit at about 5:30 in the evening, staff would go around and offer hand massages to residents without informing them that in the cream were sedatives, and then at 6 o'clock every evening, all the residents in that memory care unit would be fast asleep. That is not person-centered. That is a chemical restraint used for the purpose of staff convenience, which I think this language would clearly identify as inappropriate. In terms of benefiting everybody, residents and providers, we do have providers of assisted living facilities who call us with questions about Broda chairs, for example, wheelchairs that tilt very far back so residents can't sit up or get out. If somebody is a fall risk, this is a physical restraint that can be helpful. We have assisted living facilities who call us and say, we have residents who are fall risks, but they do want to engage in the community. They want to be at activities. They want to be with their neighbors. How do we use something like a Broda chair effectively and therapeutically to support this from happening? So we think this language really helps give clear answers in both of those types of situations to support residents and providers alike.
Questions, Chair Schumacher.
Thank you.
I almost called you Chair Newer because, you know, Lisa Timian, yeah, the hair thing is what does it, and the fact that she's from the Department of Education, and I'm like, why is the Department of Education in this committee? Since, you know, forget it. Go ahead, Joe.
Thank you, Mr. Chair, and again, we didn't hear this in the House, and so I'm wondering on this, how does this apply to families who choose, or a resident that chooses to personally have restraints set up for them? I'm not sure what the language is on that. And then the other question I would have on this is, if the center doesn't use that at all, if the assisted living doesn't use restraints at all, how does this apply to them? I'm concerned that there may be some ambiguity in this.
Ms. Rodina.
Thank you, Chair Hoffman. Thank you for the question, Chair Schumacher. Person-centeredness, as defined in 144G.08, does provide, I think, a good direction for how a resident-directed use of an assistive device that can be a physical restraint, like a bed rail, sorry, getting my words crossed there. And I think that really needs to happen in an individualized, person-centered, looking at what is important for the person and important to them, what unmet need is that bed rail meeting, and how can it be executed in a way that uses informed choice and is documented in the residence chart. So I do think there is protection and guidance for that already in statute through person-centered care and planning. And then I do also believe, and Ms. Timian can correct me if I'm wrong, but there is a portion of language here that also recognizes that if an assisted living facility does not use restraints, they can include that information up front for residents and not for the emergency manual restraints and not use those restraints.
Are they required to do the positive behavioral supports?
Chair Hoffman, positive supports is part of the 245D process for this, and it's the strategy for instead. Instead of the restraints, to prevent the use of restraints, positive supports helps to ensure that resident needs are met and that we're understanding things like agitation as communication of that unmet need.
So unlike hospitals can go ahead and just restrain without, and I know this conversation in the 245D world, Chair Schumacher and Chair Neuer, in the 245D world, that whole positive supports conversation has always been there. So, Chair, follow up.
Thank you, Mr. Chair. And I guess to the example you gave in the introduction piece there about how the wheelchair example with that, how does this language specifically address that piece there?
Ms. Timian or Ms. Rodina?
Chair Hoffman, thank you. Thank you for the question, Chair Schumacher. The language related to therapeutic use of a restraint is what would apply here with the order of a doctor with a documented therapeutic purpose for the assisted device. That would be the mechanism in this language that would help that decision to be clarified and appropriate.
Chair?
Thank you, Mr. Chair. I still have concerns and would encourage a no vote.
Okay. Senator McQuaid.
Thank you, Mr. Chair. I also do want to point members and the public, if you look on page R9A2, another piece that's really important here is hospitals notifying any facility on restraints that were used during a stay to the provider so that they have that information about what has been used, how often, so that there's that continuity of care and a clear understanding of, you know, your client, your patient, your resident is getting discharged back to you. Here's what you can expect. Here's what folks may need. So I really do, you know, there's been a lot of stakeholder work on this, and it's, again, I think this is ideally a non-controversial piece. It's just it's a gap that we have, not a new. It's not a new idea. It's one that we have all over. It's just we don't have it here, and we should. And so, Mr. Chair, I would urge members to vote yes, and I would ask for a roll call.
Roll call is requested. Roll call granted. Seeing no other conversations, we will go. Motions to adopt Senate Language Article 2, Section 7, 15, 16, 18, 28, 34. Will you call out the roll, please, Ms. Soar?
Chair Hoffman.
Aye.
Chair Neuer.
Aye.
Chair Schumacher.
No.
Senator Abler. Senator Fate.
Aye.
Representative Frederick.
Aye.
Representative Gander.
No.
Senator McQuaid.
Aye.
Senator Rasmussen. Mr. Chair, that concludes the roll call.
Chairs, we got 5 ayes. You got 2 noes and 2 ayes over here. Does not make it then, correct? The rules of the conference committee, Chair Schumacher. It is not adopted. All right. Next one we have is Chair Schumacher. Looks like your motion to adopt House Language Article 2, Section 5 as amended and Section 21 as amended. Members, the amendment should be being handed out. You got an amendment to be handed out, Joe, or you just?
Thank you, Mr. Chair. We adopted that amendment previously. This is the designated support person. I understand there may be some concern with this.
Okay.
I'm open to the discussion, but we can go to a vote whenever you're ready.
Senators Rasmussen and McQuaid, in your conversations, did this pop up?
I think they do. We do.
You guys are good? Those in favor of the Schumacher amendment, which is motion to adopt House Language Article 2, Section 5 as amendment and Section 21 as amendment, indicate by saying aye. Aye. Opposed, same sign. That is there. Members, Senator McQuaid, we're going to go to Article 2, Sections 9 and 24, but I just want to look at the time. It's 10:48. We probably want to leave by, what, 10:59? 55? All right, 10:55, we're going to go into a brief recess. Members, you can keep everything here. This is our room. There you go. Does that make sense? All right. Senator McQuaid.
Thank you, Mr. Chair. Members, this is the language that prohibits a nursing home from requiring a current or prospective resident to have a conservator as a condition of admission. Yeah, that's the language. It's very
Any
short.
questions for the good senator? Representative Chair Schumacher.
Thank you, Mr. Chair, and no questions with this, but this was part of that piece. This is the, we have agreed to language that was different than what this is and would encourage a no vote on this for that reason.
Senator McQuaid.
Thank you, Mr. Chair. Could you share the agreed upon language?
Representative Chair Schumacher.
Thank you, Mr. Chair. I was referencing the House position on this, the thing that we had talked about before with that first amendment.
Going back to the very first amendment we did. Can you help us?
Will you refresh my memory, please?
Yeah. Somebody from nonpartisan? Pinelli.
Mr. Chair, members, I don't believe we have language on the House side related to the guardian and conservator issue. I believe in the larger Representative Mueller bill that was amended out on the House side.
All right. Is that right? That's what it was. So it sounds like the language was once there, and the Mueller was doing the work on it in the House, and they amended it out. So, thoughts, Senator?
Thank you, Mr. Chair. And so then, what am I to take from the end of that sentence? That it's happening somewhere else, or?
Yeah, I don't know. Chairs Schumacher, Newer, you want to help us understand? What's your intent, man?
Thank you, Mr. Chair, and Senator McQuaid. I apologize for the confusion on that. The House position is that this language not be included in this. That was part of the agreement that we had with the Mueller discussions that we had on the other pieces that we had with that original piece. So apologize again for the confusion, but we took a position of not adopting language on the guardianship or conservatorship.
Senator.
Thank you, Mr. Chair. I will just say, I think that there may be room to work on this. It could be they can't have a blanket policy that requires every resident to have conservator or guardianship, that it would have to be an individual case-by-case basis. But I really don't want us to have said as a conference committee that as a matter of policy, like, people have to sign their autonomy away in order to receive care. And so I'm not sure who's opposed to that, but I'd be concerned. I would be concerned about the people telling us that we shouldn't do this. Do you think, Chair Schumacher, Chair Knorr, that there's room to work on a more individualized case-by-case basis language?
Chairs?
Thank you, Mr. Chair. Thank you, Senator McQuaid. If we had more time to deal, I think the bigger objection is the blanket.
June 30th? June 30th. We got till June 30th.
With this piece, Mr. Chair, I wouldn't mind if it even took longer. But I think it's the blanket prohibition that is the real sticking point on this piece of it, and that there are concerns overall that, just like we mentioned before, that some family's not always involved, and the resident doesn't always have the ability to decide in the way that is in their best interest. And without some kind of protection on the guardianship, I feel that it leads to a point where facilities are going to hedge against taking someone because they don't know what type of decision that the person's going to make in the future regarding guardianship, and that will end up being an unintended consequence, particularly with a blanket prohibition on this practice.
Senator?
Thank you, Mr. Chair. I definitely hear what you're saying. I think what I'm really concerned about, we just had an OLA report this year about guardianship and conservatorship and recommended really, really significant changes that the legislature make because of how easy it is to be placed in one, how hard it is to get out of one, how it is being abused, and then to allow for not a person or a person's care team or their family or whoever to say, you know, this is something that this individual needs, but to allow a facility to be like, hey, if you want to come in here, you got to have a guardianship or conservator. I don't love that being our trend and our law, and so maybe I'll ask that we revisit this later today because we do have time to draft something. I think it could be something as simple as instead of a blanket prohibition, you may not have any. You just can't have a blanket policy of all, right? You have to individually assess that person. You know, if you go to court to do guardianship or conservatorship, you have to present a lot of things to say here's why. I think that nursing homes should have to do the same thing. They should have to look at this person and say, you know, here's why we need it for this individual, but not to say like, hey, everybody who comes in here has got to have one. I think we shouldn't have that be something we allow to happen in the state of Minnesota.
I think perfect. In the radio world, that's a great segue to the fact that it's almost 5 minutes to the hour, and I know Senator Fata wanted to say something on this too, but you want to wait on yours? You want to just we'll just go into recess, and then that'll give you and Joe time to talk, maybe get an understanding. Schumacher, Chair Schumacher, are you the go-to person on this conversation with Senator? Members, let's go into recess. Go get yourself, just walk out the door. You go to White Castle and get some, something. Or you want to come over and watch the Senate, Mr. Chair? It's yours. Yes, go ahead. We are in recess.